Good morning, everybody. Hopefully you had a wonderful weekend. We're getting ready for our last blast of snow up here. I know everybody in the Northeast has gotten hammered this winter, but we're going to get our share here in the next day or so. So, my 5-minute money maker from last week. What really want to really become an expert and be able to immediately differentiate yourself from all competition? Become familiar enough with the AIER, from Savings to Income Retirement Drawdown. We actually have this and refer to this on our website, on our nonprofit website. So for customer consumption, or for consumer consumption. So you should be familiar with this. If you do not know what the AIER, from Savings to Income Retirement Drawdown Strategies, make sure that you download that and become familiar with it. It's a way for you to make yourself an income expert and differentiate yourself from everybody else out there. 5Q tape breakdown, a quick lesson that pay attention to the end. I give you a 5-minute easy test to give yourself that you can see how good you're doing at the system. It's $1 million test. If you want, all the guys that made $1 million or more pass this test with flying colors. So that's a good way to see if you're on track or not. So, how much is $1 trillion? There's 1 trillion seconds in 32,000 years. It shows $100, 10,000, 1 million, 100 million, 1 billion. This is a 10,000 pallets stacked too high. That's $1 trillion of $100 bills. You would have to spend $10 million every day for 273 years to reach $1 trillion. 2.7 trillion dollars. This is 1.68 times the cost of the wars of Afghanistan and Iraq, 13 times the total amount of U.S. stimulus spending. So 2.7 trillion is a lot of money or not very much, guys? Apparently you're as asleep as I am. A ton. The reason I bring that up is the amount of money in retirement. What do you think the amount of money in IRAs is right now? It's 10 times 2.7. So it's $27 trillion. 27, yeah, right, Mark, you got it, 30 trillion. So 27 million or $30 trillion in IRAs. That's the amount of retirement accounts today. So how important is our beneficiary discussion with our clients? Kind of important or really important? So we need to really nail this beneficiary. And how much time does the average advisor spend on this? A lot, or basically about the 30 seconds it takes to put the designations in there. So here's some common beneficiary errors. We're going to do a beneficiary script review today with the tape, but I want to go through just some common errors that we see with beneficiaries. First of all, not naming a beneficiary, not listing a contingent beneficiary, lacking specifics in your designation. So how important is this, guys? You got to be specific in your designation, or it can be a real problem. Failing to keep beneficiary designations up to date. Failing to keep beneficiary forms on file. When one company buys another company or a custodian changes, there is no guarantee the beneficiary designations follow. So, do companies buy out other companies? Do custodians buy out other custodians? Do mutual funds buy out other mutual funds? When that happens, there is no guarantee that that beneficiary form will go from the one company to the other company. Do you get that? So the other one is not considering financial or emotional readiness of a beneficiary, whether they're going to be able to handle the money that they inherit or what they'd be able to do with it. So what's the problem if they put estate? We don't see this often, but we do see it occasionally. What's the problem if the estate beneficiary has problems? If the estate is the beneficiary, then assets will be tied up in court, assets will be subject to creditors, extended tax deferral opportunity is gone, and all sorts of other things. Now, we don't see this very often, but you want to make sure that this happens, or if you do see this, that you understand the problem. Now, there's a problem with default languages for IRAs. The default language is per capita, and this is what we talk about in our script. That if you don't have per stirpes, but instead you just leave it as children, it's going to be per capita, and that can cause problems. Now, another problem we don't talk about, or that a lot of people don't understand, or there's a problem. Can people die simultaneously? Car crash, house fire, I mean, that can happen. So how are the assets going to be distributed to family members when you die at the same time? Now, do you ever run across people who have a second marriage? Guess how nasty it can get if there's a second marriage and it's not dealt with. Simultaneous death is not dealt with. So normally, they people generally put some, not everybody, but will put some thought into how am I going to divide these assets up when I have a second marriage. But when people die simultaneously, guess what's likely to happen? Everything that they've done goes right out the window. Everything they've done goes right out the window. So your state law is going to determine how beneficiaries are dealt with if there's a simultaneous death. So you should check to see how your state deals with this. But especially if you have a second marriage, you need to make sure that the beneficiaries are updated, that it's in writing, that you know the state property laws, because how the beneficiaries are going to be treated if there's a simultaneous death will depend on your state. And what it could do is disinherit your children completely, and all the money could end up going. Because if they do you get that, guys? So if you say that it's my wife is primary, but then it's my children are contingent, but then they determine that the wife, that you died first, it would all go to the wife, and then the wife's money would go to her children. Because once it goes to the wife, your beneficiaries no longer count anymore. So do you see how the simultaneous death could be a problem? Am I speaking Greek, or do you get that? So husband and wife die same time. Wife is the primary beneficiary. Boom, she gets it. The kids are the contingent beneficiaries, so the kids are thinking, well, we're going to get it because if my stepmom died, I was going to be the inheritor. But nope, now the mom got it, and now it's going to follow her bloodline. So that can be a real problem. So when you have somebody who has a second marriage, should this be something that you should address with them? Yes. Now, you should also make sure you consider a customized beneficiary if there's a special needs children, or if there's a child who's a spendthrift that would go through the money very, very quickly. In today's world, do we have kids that have problems with the opioid epidemic, with gambling, with can't keep a job, with being married 16 different times? Should they inherit the entire money at one time? No, because they're going to go through it in 1 year. So when these things happen, this is something that's worth discussing with your client. Do they have children who have any types of problems where you'd want a customized beneficiary? Now, there's another thing that we run into, and that is when they name the trust as a beneficiary. So it seems like a simple and easy thing to do. It is, but making it work is not. So some questions to ask is, will the custodian or plan accept the trust? Is the trust listed as beneficiary on each account? The trust document specifically drafted for an IRA or 401k, or is it just simply a general trust account? Does the trust meet 4 requirements as a stretch IRA, valid under state law? All trust beneficiaries are persons identifiable, irrevocable upon death by October 30th the following year. All beneficiaries will use the oldest beneficiary's life expectancy for RMDs. So these are all things that have to be done when you deal with a trust. And when I look at trust, guess how often I find those trusts are living up to these things. So Jeff sees these all the time. So Jeff, what would your comment be if you see a trust as the beneficiary?
Well, the first thing I would tell you is you don't see it that often. Most people will have a primary beneficiary and sometimes and sometimes not contingent beneficiaries. But when you do see a trust, because it isn't common, custodians don't really know how to deal with it. It's not standardized the way that they deal with it. Most attorneys are just going to use a boilerplate trust, which may or may not work.
Can I ask you a question, Jeff?
Sure.
It does not happen very often, but how proud are people that they name the beneficiary as trust when you do run across it?
Oh, they're very proud. They're very proud. They think they've got it taken care of, but there are a lot of pitfalls with the trust, especially like Mike talked about. Sometimes more commonly they're referred to those 4 things as the look-through provisions. Most trusts, unless they're drafted specifically for an IRA or a 401k, do not contain that language. So if you just had a general boilerplate trust drawn up for your assets and your IRA is put in there, it probably doesn't meet the look-through provisions of the IRS, which means that it's not going to work the way that you think it's going to work. The other thing that you do see sometimes and that I do get a lot of questions about is, well, what if they don't have what if they have kids, but they don't have grandkids? So if you run into that, just give me a call. I'll walk you through the slight modification to the script. Or
Can I jump in there a second,
Sure.
Jeff?
Sure.
I'm going to go ahead in the slides here. Oh. So guys, when you're collecting information here, you want to find out, do they have grandkids? So when you're doing your first meeting with them, you're collecting information. Find out if they have grandkids. If they have grandkids, I'm going to assume that the kids are the beneficiaries and the grandkids are beneficiaries. If they don't have grandkids, or if they don't have children, you need to ask what? Who are the beneficiaries? So don't go in blind. If they have children, can I assume, Jeff, that their children are their beneficiaries?
Oh, yeah. Yeah.
And if they have grandkids, can I assume that if the kids die, that they'd want it to go to the grandkids?
Yep. You can assume that.
But if they have no children, then make sure you ask, well, who do you want to get your money when you die? Ask that question, and then call Jeff or call myself, and we can help you figure out what you're going to say here. Otherwise, you're going to have to wing it when you get to that point in the meeting. So sorry, Jeff.
Yeah, and you're not going to be able to wing it. I mean, I think that's the problem, and I run into this a lot. Is one of the things that you want to do, especially when it comes to things like titling and beneficiaries, is you want to have your ducks in a row, which means 3 days before the meeting, you want to look at all your material, make sure you're going through it, make sure you're kind of rehearsing in your head what you're going to say. And too often I get a call that says, hey, I was just looking at my 21-point checklist and I realized these people don't have kids or grandkids. What should I do? Because you realize right away, oh, this meeting is in 10 minutes. I'm not going to be able to wing it. I have no earthly idea what I'm going to say there. That's not the time to be figuring that out. I mean, you're going to be ruffled. You're going to be harried. It's going to throw you off, not just on that topic, but my guess is on you're going to be thinking about it before. You're going to be thinking about it after. It's going to tilt your whole meeting and skew it in a bad way. So don't wait till the last minute.
Well, then guess what a lot of guys will do? What will a lot of guys do then, Jeff?
Skip it.
Skip it. Yeah, and don't skip it. The beneficiaries is where we almost invariably, 70% of the time, is when the wife finally says, we're moving. That guy is fired. We're done. So if it's 70% of the time, it's when the wife finally has had enough. Do you want to skip that? No. And you should never skip the beneficiary. All you need to do is figure out who the beneficiaries are. And Jeff, do they need to collect the beneficiary form to figure that out?
Nope, you don't need the beneficiary form. You'll see when we start going through the tape that the script takes into account the fact that we may not have seen the beneficiary form, which is why we ask over and over and over and over and over, how do you have it going? So that if that's not how it goes, that's how they think it goes. We know that for sure.
And if they don't have children, I mean, you need to know that up front who they want the beneficiary to go to. Is it brother and sister? Is it a charity? Is it to whoever? Maybe find out who that person is, because then we can help you modify the script so they find out that what the beneficiaries wasn't done right. And I guarantee you, if they don't have grandchildren, guess how much thought the other advisor put into it? Diddly do. So guess how easy it's going to be able to point out the problems with whatever the beneficiary is. But you got to know it up front, because like Jeff said, you need a decade of experience to be able to wing it live. I can wing it live. Jeff can wing it live, but you guys aren't at that point. So what you need to do is know who the beneficiaries are. And again, if they're children, we're going to make an assumption that children. If it's but if it's no children there, or they have no grandchildren, you got to ask what you want, where the money to go to after that. Make sense?
And the last thing I would say is, for sure, don't skip it. We used to say the power of attorney, titling, and beneficiaries were the big three. And they weren't the big three because they're so much more powerful than anything else. There's a lot of powerful topics, but they were the big three because you could do it 90% of the time with 90% of the people. The exception to that being beneficiaries. That's something you can do 100% of the time with 100% of the people. So don't skip it.
So does that make sense, everybody? Good. Thanks, Jeff. Now, there's another reason we need to be good with beneficiaries, because now with the DOL, I don't know how many people are familiar with this, but with the DOL, it says if the financial advisor is a fiduciary, and if you're DOL, are you holding yourself up as a fiduciary? Are they making you be a fiduciary with the DOL? And if you hold yourself as a fiduciary with a retirement plan, the advisor can be held liable for failing to remedy the misdeeds of other advisors. So guys, how important is it that we cover beneficiaries then? If they can hold you liable for the failing of some other doughhead who didn't know what he was doing, should we be addressing beneficiaries? And how many of our colleagues that are not 5Q advisors even know this or care about this? What would you say percentage-wise? Yeah, I'd say 0 too. Or 1%, yeah, I go with 1%. So there's lots of reasons to do beneficiaries. It's the right thing to do for the client. It's another leverage that we use to get the spouse involved and on our side. And now we've got another reason, which is if you're not doing it, you can get in big doo-doo. Make sense? So we need to make sure that we get these errors corrected. So I'll give you an example of what can happen if you don't do beneficiaries right. This is from IRS private letter ruling, blah, 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 you see up there. So they put the trust as beneficiary when the spouse died. Okay, they put the trust as beneficiary when the spouse died, but 60 days passed since the trust received the funds. So the trust received the funds because they were the beneficiaries, and 60 days passed. Well, that means the trustees were the children, and 25% was to go to the spouse. So the children were good children. So guess what they did? Children being good children, guess what they did? They gave her the 25%. But because 100% was, they gave her 100% to the spouse, which triggered taxes. And an error can't be corrected if the beneficiary is a non-spouse. But the children, so 100% was distributed to the spouse, which triggered taxes. Error cannot be corrected when it's to a non-spouse. But the children gave the spouse 25% anyway, so the rollover to the spouse was well above the $6,000 limit to an IRA. So now do you see? So they gave her the 25%, but that was over the because they had distributed from the trust. It wasn't a spousal rollover; it was just a gift. Because of that, the IRS assumed that she took that gift and put it into the IRA as a contribution, but it was well over the $6,000 contribution. Do you see where we're going here? So then, if you put in more into an IRA than you're allowed to put into, what happens, guys? What happens? Penalty, that's right. So since the excess contribution was not removed that year and not discovered until 8 years later, after taxes and penalties, guess what? Well, it's not even a non-qualified contribution, because can you do a non-qualified contribution over 6,000, guys? You are capped at 6,000. So she put in well over 6,000, so that then she got hit with excess contribution and penalties and taxes over that time period. So guess what happened to her entire inheritance from that IRA? 100% of that IRA. Guess what happened to it? Bye-bye. So that's why it's so important to do these things right. That's just one example of what can go wrong. And as we were talking about here earlier with Jeff, make sure you get, you don't need the beneficiary form. If they have children, we're going to assume, and we write 99.9% of the time, that the children are going to be the contingent beneficiaries. But if they don't have children, ask them, who are your beneficiaries then, other than your spouse, who's your beneficiary on your accounts? Find out who that person is. Make sense? Cool. So we're going to listen to an advisor during the beneficiary section to see how she does on this. She's actually does a very good job on this, but she makes a mistake and that I hear made quite often. It does get her into a little bit of hot water, and we'll see how she deals with it. So here we go.